$170 billion. That's the scale of the new immigration enforcement build-out that was funded, authorized, and set in motion in 2025, while most people were distracted by headlines that never explained what the machinery actually does to you. And if you think this is just border politics, you're not seeing the trap. The trap is administrative. Higher fees, fewer waivers, tighter screening, broader data sharing, and an enforcement posture that turns routine paperwork into a liability event. If you're planning to come to the United States, already living here on a visa, waiting for your green card, seeking asylum, holding TPS, or even preparing for citizenship, you need to stop treating immigration like a checklist. The system is no longer a service counter. It's becoming a compliance regime. And compliance regimes don't punish you with one dramatic announcement. They punish you by shrinking your margin for error until one missed deadline, one denied travel re-entry, one unpaid fee, or one old resolved issue becomes the reason you lose years. Stay with me, because in a few minutes I'm going to show you the single most dangerous feature buried in the 2025 changes: automatic escalation. Not in a cinematic way, quietly, through indexed fees, digital screening tools, and new enforcement referrals. It's the kind of change you only discover when you're already trapped in it. This is Immigration News Desk. And what we do here is not rumor chasing. We map power, what has been signed, what has been funded, how agencies actually implement it, and what that means for your real life, your job, your spouse, your travel, your ability to stay, and your ability to become a citizen without reopening old wounds. The best way to understand 2025 is to see it for what it was, not one reform, but a coordinated shift across three fronts. 1. Money, massive new funding for enforcement and massive new fees for you. 2. Structure, policy changes that change how visas are awarded, how benefits are processed, and how status is verified. 3. Posture, USCIS and DHS increasingly presenting themselves as enforcement agencies first, service agencies second. Put those three together and you get what I call a bureaucratic squeeze. Less tolerance, more cost, more surveillance, and more consequences. Let's start where the government started, with legislation that looks like a budget bill on paper, but functions like an immigration weapon in practice. In 2025, the One Big Beautiful Bill Act, described as H.R. 1, was signed into law on July 4, 2025. You need to understand the procedural trick here because it tells you how this got through. Budget reconciliation. Reconciliation is a Senate process that allows certain fiscal bills to pass with a simple majority instead of the usual 60-vote threshold. This is not an obscure procedural footnote. It's how sweeping policy can be jammed through under the banner of budget when comprehensive immigration reform can't survive a normal vote. So what did this bill actually do? According to the figures being circulated in the source text, it allocated roughly $170 billion over 4 years for immigration enforcement and border security. That number matters because funding is policy. You can argue about ideology all day. The budget reveals intent. When you quadruple resources, you don't get the same enforcement but better. You get expanded capacity, more officers, more detention, more removals, more screening infrastructure, more databases talking to each other. And here's the first open loop you need to hold. When the government increases enforcement capacity at this scale, the impact is not limited to people crossing the border. It spills into your world. Work sites, status renewals, court backlogs, airport inspections, and the quiet reactivation of old files. Later in this video, I'm going to explain why even people with lawful status should treat this as a systemic risk, not someone else's problem. The bill's funding, as described, breaks down into 3 core expansions. First, detention. Around $45 billion for detention facilities, including family detention centers, described as a 308% increase compared to the 2024 detention budget. That's not a modest expansion. That's an industrial build-out. It includes both traditional facilities and tent-based detention camps. You don't build tent capacity because you're expecting a calm year. You build tent capacity because you're planning for surge operations, mass processing, and flexible confinement. Second, Interior enforcement. Around $75 billion for ICE to expand operations inside the United States, including hiring roughly 10,000 additional ICE officers and agents over several years, plus retention bonuses, equipment, and transportation for removals. Interior enforcement is where fear becomes local. It's where your traffic stop can become an immigration event. It's where your workplace becomes an enforcement site. It's where your old paperwork becomes searchable and actionable. Third, border operations and technology. Around $60 billion for CBP, personnel, vehicles, facilities, and technology. This includes billions for hiring Border Patrol agents, bonuses, and roughly $6.2 billion for border security technology, including artificial intelligence, biometric entry-exit systems, and non-intrusive inspection equipment. Translation: more sensors, more data collection, more automated flagging, more identity verification at scale. And then there's $12 billion to reimburse states and localities for border security activities, meaning states running their own enforcement programs can get federal money back. That matters because it blurs the line between federal and state roles, and it incentivizes aggressive enforcement at the local level. Now, if you're thinking, okay, but funding doesn't affect my visa, here's the part that affects you immediately: fees. The fastest way to change behavior in a system is not to pass a new prohibition, it's to make compliance expensive. H.R. 1, as described, triggered dramatic immigration fee increases effective July 22, 2025. And this is where a lot of people will get ambushed because fee hikes don't look like enforcement until you can't renew your work permit, can't appeal a decision, or can't afford the filing that keeps you protected. Let's talk about asylum first, because the asylum changes reveal the philosophy of this era. Historically, asylum applications have not required a filing fee because asylum is a humanitarian protection for people fleeing persecution. The idea was simple: you don't price people out of protection when their entire claim is that they're escaping danger. But under the new fee structure described here, asylum now carries a $100 filing fee, plus a $100 annual fee for every year the application is pending. That is not a clerical fee. That is a pressure mechanism, because asylum cases can take years, and annual fees compound. This is how you turn a legal right into a financial endurance test. Then there's work authorization. Employment authorization documents, EADs, for asylum applicants, parolees, and TPS beneficiaries are described as $550 for initial issuance, with renewals at $275. Humanitarian parole applicants face a $1,000 fee to apply, plus work authorization fees on top. TPS registration jumped from $50 to $500 in the source text, plus EAD costs. And here comes a critical revelation that changes everything for low-income applicants. No fee waivers for some of these categories. None. That's not just expensive, that's exclusionary. It means the government is shifting from a benefits model with access safeguards to a pay-to-comply model where inability to pay becomes a form of non-compliance. Now add advanced parole. If you're in the US and you need to travel while a case is pending, advanced parole can be the difference between keeping your process alive and killing it by leaving. The source text describes advanced parole now costing $1,000. That's not a small inconvenience. For many families, that's rent money, and it forces you to choose between travel for emergencies and legal stability. Then there's immigration court. Appeals to the Board of Immigration Appeals described as jumping from $110 to $900. That is an 800% spike. And if you think that's just administrative, understand what it does. It suppresses appeals. It makes it harder to challenge errors. It makes it easier for wrong decisions to stand because people can't afford the fight. Now here's the open loop you need to keep in mind. These fees aren't static. They're indexed to inflation. That means they automatically rise every year. So even if you can afford it today, the system is designed to become more expensive over time without needing a new vote. It's a built-in ratchet. The government already announced fiscal year 2026 inflation adjustments, according to the source text, impacting ESTA, parole fees, e-views fees. Inflation indexing turns fees into a quiet escalator that never stops moving. Now we pivot to employment-based immigration, because 2025 didn't just make immigration more expensive. It changed the structure of who gets selected, especially for H-1B. In September 2025, DHS unveiled a proposal to shift H-1B allocation from a random lottery to a merit-based ranking system that prioritizes higher-paid and higher-skilled roles. On paper, the stated goal is to prevent wage undercutting and ensure the program serves specialized labor needs. But you need to understand what a merit system becomes in practice: a wage filter. And wage filters are not neutral. They privilege large employers, major metro markets, and certain industries. They disadvantage startups, nonprofits, rural employers, and early career applicants who are highly skilled but not highly compensated. If you're an H-1B worker, this matters because it changes your leverage. It changes what employers will sponsor. It changes which jobs are considered worth it. And that brings us to the number that should make every H-1B family sit up straight. The source text describes an executive order introducing a $100,000 fee for H-1B visas. $100,000. Legally, employers generally can't pass certain H-1B fees to the employee without creating compliance violations, but money is flexible. Employers can adjust salaries, hiring decisions, and sponsorship willingness. This fee, if implemented and sustained, functions like a gatekeeping tool. It doesn't ban H-1Bs. It prices many employers out. That's a soft restriction with hard consequences. And yes, this kind of fee is likely to be litigated. The authority for imposing such a fee through executive action can be challenged. But here's the danger. Even if it's eventually blocked, the uncertainty alone changes behavior. Employers freeze sponsorship. Applicants lose time. Families postpone plans. In immigration, uncertainty is a weapon because your timeline is fragile. Now add the H-4 dimension. When H-4 employment authorization is restricted or delayed, you're not just changing paperwork. You're destabilizing households. Dual-income families become single-income families overnight. Mortgage approvals change. Childcare decisions change. Long-term career paths collapse. This is how immigration policy reaches into your kitchen without ever announcing your name. And while we're talking about pay-to-play, you need to understand the symbolic pivot described in the source text. The Trump Gold Card program, announced in December 2025, described as a $1 million investment pathway to permanent residency and eventual citizenship, positioned as a revamped, streamlined version of EB-5. The message here is not subtle. For the wealthy, new doors. For everyone else, higher fees, tighter scrutiny, fewer humanitarian pathways. That is a two-tier immigration philosophy: enforcement and restriction for the vulnerable, expedited pathways for capital. Now we have to talk about humanitarian programs, because this is where the human cost becomes explicit, and where many people are still operating on outdated assumptions. One of the most dramatic changes described is the shutdown of the CBP-1 app pathway on January 20, 2025, the first day of the second Trump term in this narrative. Whatever your views on CBP-1, it functioned as a legal entry scheduling mechanism for asylum processing, and the source text indicates that from 2023 to January 2025, more than 936,000 people used it. When that pathway closes, people don't stop moving. They change routes, and when routes change, risk increases. Then humanitarian parole programs were ended or restricted. CHNV, processes for Cubans, Haitians, Nicaraguans, and Venezuelans, were heavily impacted, and the source text describes a Supreme Court decision on May 30, 2025, allowing the administration to end parole status for people who came through those programs. If you are one of those paroles, or you have family who is, understand what parole means in U.S. immigration law. It is temporary permission, not an admission. It can be terminated. It is inherently precarious. And when it is terminated, your options depend on what other filings you have in place. Uniting for Ukraine is described as paused and later resumed with modifications, but under threat. CAM parole and family reunification parole programs were suspended. USCIS stopped accepting Form I-134A applications for many parole processes. That's a procedural closure that destroys whole pipelines. Now, TPS, Temporary Protected Status, has seen terminations and threatened non-renewals. TPS was created in 1990 as a bipartisan tool. When countries face war, natural disasters, or extraordinary conditions, you don't force mass returns into chaos. TPS is temporary by design, but it often becomes semi-permanent for communities because crises don't resolve on congressional timelines. The source text describes terminations for multiple countries, including Venezuela, Haiti, El Salvador, and others, with 60 days notice to leave and a $1,000 cash incentive offered for voluntary departure. Whether that incentive program is effective or not, the strategic logic is clear. Move people out without protracted proceedings. And if TPS designations expire without renewal for multiple countries, the U.S. could theoretically reach a point where no one remains under TPS for the first time since 1990, as described. Now keep this open loop. When humanitarian programs are terminated, enforcement capacity matters more, because the same people who were temporarily protected now become removable unless they find another legal foothold. This is where the $170 billion enforcement build-out and the humanitarian terminations become one machine. Now let's talk about refugees, because refugee policy is where humanitarian commitments meet national security framing. The source text describes a 90-day suspension of refugee resettlement starting day 1 of the second term, plus a review of all refugees admitted under the prior administration, with admissions remaining low and case-by-case exceptions. If you're a refugee applicant, understand that refugee resettlement is one of the most politicized pathways because it is discretionary at the sovereign level. It expands or contracts based on administration posture, and when it contracts, the consequences are global. Camps overflow, dangerous routes increase, and families remain separated for years. Now we pivot to naturalization, because a lot of you assume citizenship is the end of vulnerability. It is more protected, yes, but 2025 tightened the path to get there and expanded scrutiny on the way in. The source text describes a modified civics test for N400 filings on or after October 20, 2025. More questions, higher difficulty, higher correct answer requirements. Historically, the civics test has been adjusted before, and test changes are often justified as raising standards. But in practice, increased difficulty combined with increased processing scrutiny produces more denials, more refilings, more delays, and more fear. Then there's the good moral character standard, described as being interpreted more strictly with increased scrutiny of tax compliance, past immigration violations, minor criminal history, and public benefits usage. Good moral character is one of the most elastic concepts in immigration law. It can be applied fairly or weaponized. When an agency decides to interpret it more aggressively, you feel it as unpredictability. What was overlooked before becomes disqualifying now. The source text describes a 24% increase in citizenship denials and longer processing times. And then comes the phrase that should make you sit still: denaturalization escalation, 100 to 200 denaturalization referrals per month for legal review. Denaturalization historically has existed to address fraud. Someone lied to obtain citizenship. But in a heightened enforcement climate, the fear is scope creep. The window of vulnerability expands. Old issues become reopened. People who thought the chapter was closed find themselves audited. Now, I'm going to open a critical loop. The worst citizenship mistake in an aggressive era is filing without auditing your own history first. Later in this video, I'm going to tell you the exact categories of old problems that resurface during naturalization and how you reduce that risk before you hand the government a new application that invites scrutiny. Now we talk about green card holders, because lawful permanent residence is being treated differently in practice, even if the statute hasn't retroactively stripped status. The source text emphasizes that green cards remain valid, but enhanced screening at ports of entry is now standard, with deeper reviews of travel history, employment status, tax compliance, and ties to the U.S. If you travel frequently or spend long periods abroad, you are more exposed. Not because you're guilty, but because your travel creates questions about residency intent. Add reporting requirements. Address changes within 10 days, certain employer change reporting depending on category, and reporting arrests even if charges are dismissed. This is where people get blindsided. They think dismissed equals doesn't matter. Immigration doesn't work like that. An arrest can trigger scrutiny even without conviction, depending on context and how it intersects with admissibility, removability, or discretionary standards. Now we reach the enforcement posture shift, and you need to understand how cultural changes inside agencies translate into your outcomes. The source text references USCIS leadership statements that USCIS must be an enforcement agency at its core, plus the creation of new enforcement-oriented positions described as Homeland Defenders, with massive application volume and deployments beginning December 2025. Whether you agree with that direction or not, the practical consequence is this. Benefit adjudication becomes more adversarial, more fraud referrals, more requests for evidence, more denials framed as integrity. When an agency's identity changes, its default assumptions change, and you feel that as delays, skepticism, and reduced discretion. The source text also describes internal culture shifts, signs urging people to leave the country, staff departures, union changes, morale collapse, and the requirement to re-interview refugees admitted during the Biden era, creating backlogs. Even if you don't care about internal agency morale, you should care about what it does to your case. Churn equals inconsistency, inconsistency equals errors, errors equal denials, and denials equal years. Now, DACA. As of February 2026 in the source text, renewals remain open, first-time applications are not processed, Texas recipients face uncertainty, and the future depends on litigation and legislation. Here is the practical truth. DACA is a legal battlefield, not a stable statute. If you are a DACA recipient, your survival strategy is relentless compliance, timely renewal, documentation, and legal counsel when travel or advance parole is involved, because the program's fragility turns small mistakes into existential threats. And then there's the diversity visa lottery, paused indefinitely in the source text after a 2025 Brown University shooting, with undisclosed changes and no timeline as of February 2026. DV has always been politically vulnerable because it is framed as random. But for people from low immigration countries, DV is often the only realistic green card pathway. When DV is paused, you're not just changing a program, you're erasing hope for entire populations. Now, I promised earlier that I would explain the single most dangerous feature in this era: automatic escalation. Here it is. When you combine inflation-indexed fees, digitized screening, expanded enforcement staffing, and tighter adjudication posture, you create an environment where small issues escalate automatically. You don't get a phone call. You get a denial notice. You don't get a warning. You get a missed deadline consequence. You don't get discretion. You get a rules engine. That's why the advice "don't delay" is not motivational. It's structural. In tightening regimes, procrastination is punished because the system doesn't wait for your readiness. So what do you do now practically, without spiraling into panic? First, if you have any application pending or you plan to file, stop delaying. File when you are eligible and prepared. The backlog doesn't reward patience, it punishes it. And policies can close overnight. What exists today may be narrowed tomorrow. Second, document everything like you're building an audit file. Copies of immigration notices, entry and exit records, pay stubs, tax returns, lease agreements, proof of U.S. ties. If you are ever questioned at a port of entry, or if you face a status review, or if you later apply for citizenship, documentation becomes your defense. Third, treat travel as a risk calculation, especially if you are a green card holder or in a fragile status. Long absences create abandonment questions. Travel during pending cases can create re-entry complications. If you must be abroad for extended periods, explore a re-entry permit before leaving. If you're on a temporary visa, Make sure you understand re-entry risks and documentary requirements. This is not fear. This is operational reality. Fourth, stay informed through official sources. USCIS, DHS, CBP, State Department, the Federal Register. Social media is where misinformation thrives because fear performs. Verify before you act. Fifth, consult an immigration attorney if your case has complexity. And be honest with yourself about complexity. Criminal history, prior immigration violations, employment changes, conditional residence, travel patterns, gaps in status, pending court matters. These are not minor. In this enforcement posture, they are tripwires. Sixth, if you are eligible for naturalization, consider applying sooner rather than later, but only after auditing your history. Citizenship offers stronger protections than a green card, but the path has become more scrutinizing, and filing blindly can reopen old issues. This is where strategy matters. Filing at the wrong time can create more exposure than waiting a few months to fix a problem. Seventh, know your rights during enforcement encounters. If ICE comes to your home, you do not have to open the door unless they have a warrant signed by a judge. You have the right to remain silent. You have the right to speak to an attorney. And you should understand the difference between an administrative warrant and a judicial warrant. This is not abstract civics. It's family survival. Eighth, prepare financially. Immigration is becoming more expensive by design, and those costs are indexed upward. Budget for renewals and filings like you would budget for insurance, because in a tightening system, missing a renewal due to money is not a mistake. It's a crisis. Now, what's coming in 2026 and beyond? Expect more litigation, more program modification, more fees, and more intercountry pressure. The source text notes that countries that refuse to accept deportees or don't provide adequate identity verification face visa restrictions and sanctions. That's a geopolitical lever. It means your nationality can become a policy variable even if you personally did nothing wrong. And yes, election cycles influence policy. But don't build your life on political predictions. Many of these changes, once funded, once staffed, once built into systems, persist. Bureaucracies rarely give back powers they have already operationalized. Here is the final truth you need to carry with you. The U.S. immigration system in 2025 did not simply tighten. It structurally reoriented, from benefit facilitation toward enforcement-first governance, with a pay-to-comply fee architecture and a surveillance-grade verification posture. That doesn't mean opportunity is dead. People will still get green cards. Families will still reunite. Skilled workers will still find pathways. But the cost of mistakes is higher, the tolerance for ambiguity is lower, and the system is less forgiving than it has been in decades. So don't outsource your future to hope and rumor. Build a strategy. Document your life. File early and correctly. Treat travel as a serious decision. And get professional guidance when the stakes are high, because right now, the stakes are always high. If you want ongoing, verified breakdowns of these changes as guidance is released and court challenges evolve, subscribe here at Immigration News Desk. And if you know someone who is still operating on 2023 rules, share this with them. The most dangerous immigrant in 2026 is not the criminal. It's the unprepared person who thinks the system still works the way it used to. Stay informed, stay organized, and stay ahead of the bureaucracy, because the bureaucracy is already moving.